We'll hear argument first this morning in case 22-324. We'll hear argument first this morning in case 22-324. O'Connor-Ratcliffe versus Garnier. Mr. Mupan.
Mr. Chief Justice, and may it please the Court. Individuals who hold public office are still private citizens too. When acting in their personal capacity, they retain their First Amendment rights to decide who can participate in a community discussion that they host at their own property. They are thus free to block users from their personal social media pages unless they chose to operate those pages in their official capacities instead. The only principled and workable test to determine the capacity in which they acted is to ask whether they exercised any duties or authorities of their job. And the answer is plainly no, where, as here, the state itself did not control or even facilitate their operation of the pages. The officials thus wielded no greater rights or privileges than any other private citizen denying access to their own property. The Ninth Circuit instead held that even if an official was not actually doing her job, state action exists so long as the page's appearance made it look like she was. But that type of reasonable observer inquiry is incapable of consistent application. It is also fundamentally misguided because the official's power to block does not invoke the page's appearance at all. Respondents alternatively insist that petitioners were doing their jobs simply because they used the pages to communicate about their jobs. But that is the type of excessively broad job description this Court has repeatedly rejected. Because officials could operate such pages in either capacity, the state action test should require clear and objective evidence that is capable of differentiating between the two. That is essential to preserving the robust sphere of individual liberty the doctrine is meant to protect. I welcome this Court's questions.
Counsel, if you had the exact same exchange here, but from an official site of the school board, would it make a difference?
Yes, Your Honor, that would be state action because that would be exercising the power.
Okay, so let's assume that the official has discretion to either do this on the school site or the school board site or on the personal computer. What's the difference in what the communication is?
So in your first hypothetical, the power that's being wielded is the power to exclude someone from government property. Just like if it was a government building, the power to block someone from entering main justice is state action. In the actual case, what is happening is being excluded from private property, and the power to exclude someone from private property is private.
Well, let's talk about that just briefly. What if you can access the site remotely from petitioner's computer at home, but it is the school board site, and it's not on government's computer?
Well, the question is who controls the account, and in this case, it's undisputed that this is the account that belongs to petitioners in their individual capacity. It's an account that they created before they held office, and it's an account that they will continue to hold after they leave office. So,
is this a site-by-site determination or a message-by-message? In other words, let's say you have, a site that's used every now and then for what you might characterize as official announcements, but the rest of the time it's, my child got a, blue ribbon or something like that. Do you say that, well, you look at each episode of blocking or whatever as governmental because they use it for governmental things from time to time? Or do you say, well, they block them for this? In other words, you go through the whole analysis with respect to each back and forth.
So the specific conduct that's being challenged here is the blocking. And so the question is the blocking official action? In general, I think that that's going to be answered at a site-wide level. It's either a government account or it's a personal account. And that's true even if some of the speech could be viewed as official. So if, for example, a government official made an official announcement that at a campaign rally, the announcement, the speech, might be viewed as official in some sense, but that wouldn't convert the campaign rally into a government forum where there was a constitutional right to enter.
But I'm not sure I followed the answer, but let's say what percentage of governmental blocking or back and forth do you have to have before you say, oh, every blocking episode should be quickly characterized as state action?
Well, so I don't think it turns on a percentage, Your Honor. In general, when a public official is using their personal property to engage in speech that they can engage in either capacity, the right way of thinking about that in general is that all of that speech is personal. Now, I concede that if...
sorry, all of that, all of the speech on that site?
Yes.
Okay.
Because that is speech they can engage in either capacity. Now, I do agree that there are certain things that they could do on these pages that would be governmental and for which there was a right of access. So, for example, the SG's office used the example of doing notice and comment rulemaking on a social media page. That's, of course, inherently governmental, and if they're excluded from that, that would be state action. And I would agree that that would be true whether they use the page in general for notice and comment rulemaking or just once.